Welcome everybody to the 2024 Barak-Wonga Oration. And the Vice-Chancellor was just talking before, it's become a really important tradition at Swinburne, and we've had some great speakers over the last 6, 7, 8 years. I think the first one was 2016. The only reason I know that is because we're busy doing some research for a submission, so we've had to go back and do our research, which has been really, really useful. So before we start the official part of that, I'd like to call Uncle Colin Hunter to the stage to do Welcome to Country. So thank you very much, Uncle Colin.
Yeah, thanks, John. Look, I want to start by acknowledging that this evening we are meeting on the lands of my ancestors, the Wurundjeri people. And I want to take this opportunity to pay my respects to my elders, both past, present and emerging, elders from all nations, but I particularly want to pay my respects to having gathered in the room this evening. But I always like to acknowledge the mob, the Aboriginal and Torres Strait Islander people joining us. I'd like to acknowledge you all, but individually and pay my respects to you all. But I want to acknowledge you, Pascal, too, sitting over there hiding. No. I just want to acknowledge you and pay my respects to you also. Woman Jekka, welcome. Wurundjeri Balak, Yemen Kondi Pik. The Wurundjeri people welcome everyone to land today. Wurundjeri no Bunambor War, Kondi Negnak Dublin Bik Bulik Bor Tilligan. The Wurundjeri people want to look after and protect the land as they did long before. Wurundjeri country extends from the inner city of Melbourne. It goes across the mountains of the Great Dividing Range, west to the Werribee River, south to the Murdialek Creek and east to Mount Borbor. And the Wurundjeri people are part of the Kulin Nation and of the Walrong language group. Hello, my name is Colin Hunter Jr. or Willett, meaning possum. A name given to me by my grandmother as a young boy. I'm a proud and passionate 7th generation Wurundjeri man and a direct descendant of Bibijan, who was Nullangeta or head of the tribe at time at first settlement. And it's through my grandmother Gumbriar, meaning white dove, or only tiny or nana, she was known to all us mob, that I got Aboriginal culture and heritage in my life today, so for that I say thanks, Nan. My grandmother was one of the last of the Aboriginal people born in the early 1920s up at Corandack Mission in Hurstville, before she got pushed up to Barham on the river in New South Wales. In Aboriginal culture, a great deal of respect is given to the land, the plants and animals alike. And as always, got my beautiful gum leaves. I'll place them up the back of the room up there somewhere. And if you get an opportunity before you move out tonight, please take a nice one and put it in your pocket for the evening, please. The ceilings will keep you safe along country and give you the access to the resources while you're on country. And while you're on Wurundjeri country, you're most welcome to the traditional lands and the waterways of the Wurundjeri people. So, Woman Jekka, welcome. Look, it'd be a bit remiss of me to walk away from this lectern without paying my respects to the two men, mate. To Uncle Simon and Uncle William. You know, as I get around Melbourne, you know, they're only 8-year-old boys when they witnessed that Batman treaty with their old man, Billabillomia and Bebijan. You know, and if you fast forward just 21 years to 1856, the Victorian census tells us we're under 20 Wurundjeri people left. We're 17 ton wrong, I think. But them two men, you know, both very different. You know, Simon didn't have a long life, but I tell you what, he was an astute horseman and it can mimic any animal in the bush. And his cousin, wow, what a negotiator. Well before his time. They had many a deputation from Corandack to Premier Barry's office, smacking on his door, fighting for better conditions at Corandack, where both my grandmother and great-grandmother were born. You know, he just knew there was a new world coming, and he was well ahead of them. They just didn't listen. What a shame. I'll leave it with you.
Thank you very much, Uncle Colin. Next, I'd like to invite Professor Kester to the stage. Professor Pascal Kester is the Vice-Chancellor and President of Swinburne University of Technology. Before joining Swinburne in 2020, Professor Kester was Deputy Vice-Chancellor and President Academic at the University of Adelaide. It might no longer be University of Adelaide, it might be University of Adelaide in South Australia soon. Professor Kester is an active and respected researcher in the areas of consumer behaviour and marketing communications. Her qualifications include a Bachelor of Business Administration from her native France, a Master of Arts Marketing from Ohio State University in the United States, and a PhD from Massey University in New Zealand. In 2023, Professor Kester received one of France's highest honours, the Medal d'Officier de l'Ordre National de Mérite. In 2007, she also received France's highest academic recognition by becoming Professor de University. Professor Kester holds a number of positions in the education and business sectors, including board member of the University of Australia, Chair of the University of Australia Teaching and Learning, Student Success and Welfare Standing Committee, Deputy Chair of Victoria's Vice-Chancellor Committee, and Governor of AmCham. Professor Kester has held several visiting professional appointments, including La Sorbonne, Paris, ESSEC Business School, and the University Nancy in France. Would you please welcome Professor Kester?
Thank you very much, John. It's always worth it just to listen to you speak in French. Thank you very much. And a very special thank you also to Uncle Colin over there, because every time he does a welcome to country, we feel that it is a strong affirmation of just the importance of how history rolls out and keeps us true to what it is that we're here to do on the land of the Wurundjeri people of the Kulin Nation, a land where learning and teaching has occurred for thousands of years, and where we are only picking up the baton from the elders and hoping to continue in that tradition of growing the human capital of people who will take care of the earth in the future. So thank you very much, Uncle Colin. For those of you who are not familiar with our campus, I hope that you've had the opportunity, now that the fog has lifted, you've been able to walk on our campus and see that one of the things that we were very proud to be able to deliver in 2024 was actually to manifest our connection to the Wurundjeri people of the Kulin Nation by having learning circles that were designed in co-creation with the Wurundjeri elders and now grace all our three campuses here at Hawthorne, but also at Croydon and Montana. And if you haven't, I invite you to always, when you are on campus, to go and just, I suppose, reflect by spending a bit of time there. I'm lucky enough to see it from my office, and I always enjoy seeing people who are just sitting there and contemplating the role we play, each and every one of us in that long history. It is a tradition now to be able to get together to think and reflect on the role that we all can play in reconciliation. And this is one of the great events of the year. So it's always nice to have our people gathering around to listen to a leader in the Indigenous community. And I would like to welcome and acknowledge our keynote speaker for tonight, who is Dr. Terri Janke. We also have a couple of other people that I'd like to acknowledge. We have Dr. Auntie Lois Peeler, AM, who indeed delivered the 2020 oration and who I believe might be here with her daughter, Tanya Peeler, who is Executive Director and Principal of Wara Aboriginal Girls College in Hillsville. And we also have members of the Swinburne Council and the Swinburne Executive with us today. On behalf of Swinburne, I'm delighted to welcome you to this now traditional Barak-Wonga Oration, which is hosted by the Munalin Tumodul Centre. And again, if you've had the opportunity to walk around the campus, you will see that we were able to develop a special place for our Munani Tumodul colleagues, a place that we were able to have an appropriate decor and mural to indicate that this is a beautiful connection between the past and the future. It's a special event that is named after two significant Wurundjeri leaders, Barak and Simon Wonga, whom Uncle Colin referred to. Both of them were cousins, and they shared a lifelong dedication to advocating for Aboriginal rights and protecting Aboriginal culture, history, and customs throughout the late 1800s and early 1900s. And like William and Simon, I think our past speakers at the event have all been prominent leaders in the Aboriginal communities. Our speaker tonight, Dr. Terri Janke, is no exception. Terri is an international authority on Indigenous cultural and intellectual property, and intellectual property is something that's very important in the world of innovation and technology, so it's a very, very good alignment with what it is that Swinburne is passionate about. And Terri has always been dedicating a time and passion in protecting the rights of Australians' First Nations people to their heritage, which incorporates traditional knowledge, cultural expression, and cultural objects, just to name a few. This is a fascinating and important area of work that truly embodies the spirit of the Barak-Wonga Oration. This annual event is one of the ways in which we show our commitment to reconciliation here at Swinburne. Swinburne is a place where Aboriginal and Torres Strait Islander people and their heritage, culture, and spirituality are valued, respected, and indeed celebrated. The staff and the researchers at the Mundani Tumbadu Centre and the National Centre for Reconciliation Practice, which is part of our RAP, are actively working to drive systemic change and key national outcomes on reconciliation in Australia. We were the first university in the country to achieve Elevate status for our 2017 to 19 Reconciliation Action Plan. And we remain one of a very small group of organizations at this level with our current RAP. And the reason why the pressure is on, and I'm looking at John very meaningfully here, is because we are putting the final touches on our next RAP. And of course, there is absolutely no way we want to do any less than maintain that Elevate status. And I know that John has been working very hard in relation to what it is that we can do that is not just about talking about it, but making an impact on people. And I was very fortunate this last year to be able to go to the Garma Festival with John and with our Chancellor. And it was a really important point because of the difficult challenge of this year and the outcome of the referendum and the way Indigenous people perceived what it was that was said. And I've got to say, going along with John, that when I went there, I thought there would be a lot of anger and a lot of frustration and a lot of argument. And what I found was actually an incredible display of strength and resilience, but also of a pragmatic view of what do we do next. And I think that this kind of really embodies what it is that Swinburne wants to do too. We can talk about it, or we can do the things that really matter and make a difference in people's lives. And our next RAP is actually all about what it is that Swinburne can quite uniquely do that will make a real difference in people's lives. So really one of the highlights of the last year has been the way in which we manifested this in the configuration of our space with the learning circles, but it's also very much our commitment to growing talent and increasing the number of Indigenous people that can join our ranks and in our mission. And so one of the highlights has been the appointment of the first Swinburne CSIRO Indigenous Researcher Fellow, an associate professor, Sally Waller, and she's a spatial ecologist, and she's working collaboratively with Indigenous communities around the country to better understand and manage water quality in remote Australia. And of course, the best way to do this is to do this from space, which happens to be one of the things that Swinburne is very keen on too. So it's another way in which we are showing our commitment. It is about making an impact on people's lives, but it is also about in our own community of researchers and teachers to have Indigenous people coming to share their wisdom. So there is no doubt that in what is otherwise a very challenging year with the result of the referendum, we continue to be optimistic. We look to the future, and we're committing to embedding and strengthening reconciliation throughout everything we do in the university. We will never waver in our commitment for voice, for treaty and for truth, and we want to advocate this loudly and proudly. To close, I want to thank you for being part of this evening and for joining us. Terri, we are really grateful for the time and expertise that you will share with us tonight, and we're very much looking forward to hear you speak, and also to continue to share with you on this commitment to ensuring a better future for all people. Thank you very much.
Thank you, Professor Kester. I'd also like to add another note of a new appointment. We're about to appoint Dr. Kirsten Banks to the Ausgrav ARC Centre, and Kirsten is a noted astronomer in the STEM area. So we are making some progress in some of these really key areas which are difficult to recruit for. So I'm sorry that wasn't in your notes for tonight, Pascal, but I've only just known through the week. Just to continue, an introduction now for Dr. Janke. Dr. Terri Janke is a Wuthathi, Yadhaigana and Meriam, an international authority on Indigenous cultural and intellectual property, and the creator of the True Tracks framework for best practice Indigenous engagement. She is the owner and Solicitor Director of 100% Indigenous owned legal and consulting firm, Terri Janke and Company. Dr. Janke is a leading expert on the intersection between AI, and we've all seen lots of discussion about AI, and international cultural intellectual property. Her team have facilitated and presented workshops on the topic for clients and general audiences, and are assisting several AI-related matters. Dr. Janke is a trusted advisor and currently appointed as a member of the Copyright and AI Reference Group established by the Attorney General's Department, and the Temporary AI Expert Working Group established by the Department of Industry, Science and Resources. Terri was admitted to practice in 1995. She holds an unrestricted practicing certificate and is a member of the Law Society of New South Wales. In 2019, she was awarded a PhD from the Australian National University for her thesis, True Tracks, Indigenous Culture and Intellectual Property Principles for Putting Self-Determination into Practice. Terri is a graduate of the Australian Institute of Company Directors and Resolve Mediators. She has held numerous board positions such as the National Gallery of Australia, the Australian Copyright Council, National Centre for Indigenous Excellence, State Library, New South Wales, Jarwin, Tourism Australia, First Nations Rugby Committee, National Indigenous Television Chair, and Nagalia Indigenous Lawyers Association. Terri is also an adjunct professor for UTS Business School and the University of New South Wales Faculty of Science. Could you all give Terri a welcome?
Thank you for that really warm introduction. Debbie Key, good afternoon. Mayim, hello. I'd like to acknowledge and pay my respects to country. Thank you so much, Uncle Colin, for the wonderful welcome. And I just felt your words in my heart when you spoke. Thank you for welcoming me here. It's beautiful to be here again. And it's really important that we acknowledge country and the resources and the beauty and the things on them that our ancestors, your ancestors, have cared for. So good evening, everybody. To everyone, distinguished guests. Vice Chancellor, thank you for your introduction. It's really good to hear about your great commitments to the RAP. And John, thank you for that long introduction about me. I know we've known each other for ages, and I'll pay you later. But I'd like to begin by just paying my respects to the Wurundjeri of the Kulin Nation whose lands we gather. And I acknowledge their ancestors, warriors like William Barak and Simon Wonga, whose leadership and vision inspire us to honour the past while imagining a future founded in truth and justice. Now, I'm a Wuthathi, Yadhaigana and Meriam woman, which is from quite further north than here. I have Aboriginal Eastern Cape York heritage and Torres Strait Islander heritage. I live in Sydney and Warrane on Bidjigal country, where I have a firm of lawyers there. And I specialise in Indigenous knowledge and Indigenous cultural and intellectual property. some of you may recognise people in this picture here. I have Gillian's daughter here, Claire, who works with me, and also one of your esteemed graduates, Niani Carter, is one of the young First Nations lawyers with the team, and she's a graduate of Swinburne. And last week I was here in Melbourne when she won the Women in Law Indigenous Lawyer of the Year, which was pretty exciting. One of your graduates. And we all work together. We're a group of First Nations and non-Indigenous people that work to the common goal of empowering First Nations people to prosper in their arts, culture and business. And we've been doing a lot of thinking around this intersection between Indigenous cultural and intellectual property and AI. That's not Aboriginal intelligence, I mean artificial intelligence. It's where ancient cultures are meeting a new landscape. And at this crossroads, we encounter an immense opportunity, like it's transformative. But there's also profound risks to culture. For Indigenous people, it's not just about the advancement of technology, it's about whether these advancements are respectful and empower our cultures and not just turn them into commodities where they're demeaned or marginalised. We still need to be in control. So what is AI? Well, artificial intelligence, or AI, refers to technology that can perform tasks usually requiring human intelligence. And it's like recognising patterns, making decisions, or translating languages. And AI works by analysing large amounts of data, and it's often collected or scraped from the internet, and they learn and improve off those sources. And examples are like what I'm showing on the screen. We have ChatGPT. Most people would be using that by now, is that right? People using ChatGPT? No? What about Deep AI, OpenAI's DALL-E, Stable Diffusion, and Midjourney? They're some of the ones that do artistic works. So they're moving at the rate of knots. The intelligence of these things is just getting greater and greater. The generative AI is such a top speed. But the problem is that AI doesn't ask permission to use data. It can scrape the internet and include things like artworks, knowledge, without seeking consent. And this is where I like to think that AI got no dreaming. It's got no dreaming, has it? It steals from other people's ideas, really. It mines content. AI doesn't have roots in story, connection, or place. And instead it mines the content it is fed, pulling from what's already said, drawn, sung, or shared. It's a large language model, which bases the outputs on patterns in existing data. While AI can quickly generate responses, it translates languages or mimics artistic styles, it does so without the cultural and ethical grounding that humans bring. For Indigenous peoples, this raises significant concerns, and many of these tools are not owned or controlled or designed by us, and we often don't understand or have access to how they work. And there are, as a result, inherent biases. And biases are built in the machine by the priorities of those who create it and not by the communities affected by them. So if we see an increased use of AI in our daily lives occurring now, all sectors, government, industry, research, education, universities is a big sector, and also the arts. They're all embracing AI to transform everyday practices. And AI has become synonymous with innovation and revolutionising how we interact with the world. From streamlining processes to uncovering new possibilities, its rapid expansion presents both significant opportunities but these serious risks. So for Indigenous peoples, there's risk, especially concerning government use, that to make decisions in critical areas like healthcare and the legal system. So while AI can prove effectiveness and accessibility, It operates within frameworks that lack this cultural understanding, and it's shaped by systemic biases. So these biases disproportionately harm First Nations community and further entrench existing inequalities. In healthcare, for example, AI might be used to allocate resources to predict health outcomes, but without culturally appropriate data or consultation or involvement by our Aboriginal community control sector, the decisions could miss the mark. Indigenous health needs connection to Indigenous people, to country, because that's the uniqueness that we bring to it. Yet AI systems can overlook these factors, and that leads to inadequate care and misdiagnoses. Similarly, in the legal system, AI could be employed to predict criminal behaviour or inform sentencing decisions. However, when trained or biased data is put into the system, we could risk perpetuating discrimination against Indigenous people. And this exacerbates already existing treatment. In education and research, AI may emphasise existing problems that a lot of the information written about Indigenous people is not written by Indigenous people. And it might be told through a colonial lens, a deficit language, and it's not respecting cultural protocol. So AI can generate answers and provide information that's not true. It hallucinates, and it's not based on living culture connecting with people. So as AI becomes more ingrained in our decision-making within society, it's crucial to address these risks. The rapid pace of AI it's got to be matched with safeguards and things like Indigenous-led governance, protocols like the True Tracks principles, and Indigenous data sovereignty, and I'll talk more about that later. But we have to embed this cultural understanding and self-determination into the systems to ensure that technology benefits Indigenous peoples rather than deepening these challenges that we already face. So just to recap on what is the impact of AI on Indigenous cultural and intellectual property, it's a system that learns by consuming from amounts of data. Can you imagine all the things that are already in collections held about Indigenous people? We're looking at images, films, storage, voices, languages, patterns. There's a danger that this knowledge can just be uploaded on the internet. Language recordings can go up. Things that were collected for cultural preservation and used in new ways without any consent. And so I'm saying they have no consent, no connection to country or culture, and they can be exploitative and extractive. And we're seeing now where more and more industries are looking to use knowledge for commercial gain. We're looking in biotech. Not to say that this is wrong, but First Nations people must be there with the profits, and it cannot be exploited without the community. So let me talk now about the nature of Indigenous knowledge and Indigenous cultural and intellectual property. And you'll hear me say ICIP or ICIP as a shortcut to that long words, Indigenous cultural and intellectual property. When I'm talking about Indigenous cultural and intellectual property, I'm talking about Indigenous people's rights to their knowledge. And it's their cultural heritage, their traditional knowledge, their traditional cultural expression, which is a very interrelated, large knowledge system, really. And what I'm showing here is anything from art, story, and design to documentation of Indigenous peoples, like films and records of the government's field notes of anthropologists, for example. Traditional, scientific and ecological knowledge is there. Cultural property, things that are held in museums. Immovable cultural property, which is land, seas, and stories associated with them, songlines. It includes ancestral remains. It includes languages. And they're all connected in the circle there because they are interrelated and part of that complex system of knowledge. And they're from land. They're from people's connections to country. It's communal these rights, part of our birthright as First Nations people. It's living culture handed down through the generations. And the practice of speaking for country is actually the cultural practice. And then there's also the fact that it's so linked to our identity and the challenges for that in the modern world when we're revitalising a lot what has been held back from us as colonised people. These rights become very, very important. ICIP is about self-determination, these rights, ensuring that First Nations people control how their culture is shared and used. And when we look through a lens of copyright, we can see the limitations of the law. And as a lawyer, learning about copyright, I could really see the limitations as opposed to the way that First Nations see their rights to hold knowledge and speak for it. In a copyright situation, it is only an expression or a material form piece of information that is protected. Whereas for cultural laws, in cultural laws, cultural works, stories, styles, themes, to talk about place is part of what's protected. You don't need to be registered for copyright. It exists as soon as it's created. So there's a whole system that is imposed on relationships when there are transactions with sharing knowledge by First Nations people to researchers, to anthropologists, to mining companies, biotech, and all of that. So we watch the rights of copyright in that respect. But copyright will look to give the right to an individual author. So it is the person who makes the material form, the author of the record, that becomes the owner of it, who can control it. And it doesn't recognise this communal custodianship of the collective having a say. There's the economic rights that underpin copyright. And with ICIP, cultural rights are an important part of why First Nations people are wanting to control ICIP. We can assign rights in copyright by giving it away totally, and we need writing to do that, but it is possible to assign someone's story to country in writing, to a publisher or to whoever. And we've seen examples of the artwork of Albert Namatjira assigned to a publisher, now returned to the family, but very much after the copyright period has run with only a few more years to go. Limited duration for copyright, 70 years after the death of the creator of the work. So it does not protect things like rock art. That is hundreds of years old, but stories, mimi figures, Wandjina images, the right to control those belong to First Nations groups that are, the descendants of that culture, but they would be out of copyright from a Western copyright lens. And it is within this gap in the law that First Nations people are calling for greater rights. And within Australia, we've been doing that, and internationally too. So the United Nations Declaration of the Rights of Indigenous People includes Article 31, which asserts this right to maintain, control, protect and develop cultural heritage, traditional knowledge, traditional cultural expression. And it's a very important document, this one. It doesn't translate into Australian domestic law as a piece of legislation. It can be persuasive on policy, but as yet it is not binding. And this is where First Nations people are calling for greater rights. And within the ICIP space, those rights are the rights to free, prior and informed consent, the right to be recognised as primary guardians and interpreters of their culture, the right to authorise and refuse use, to benefit commercially when it is authorised use, and to prevent derogatory use or demeaning use, and to maintain secrecy. These are all important rights that First Nations people want. But if we look in the challenge, even without AI, the challenge of consent. A central tenet of Indigenous cultural and intellectual property is the principle of free, prior and informed consent. However, The sheer scale of AI makes meaningful consent challenging. Often Indigenous communities will not even be aware of how their cultural heritage might be used. Let's think about how it might be put into a computer to train AI where it's scraped. How would First Nations people know? They may not be the authors of the content that's being uploaded. Who owns the AI generated content if the machine is making it? The machine is not a human, so it cannot own the copyright it creates. Is it the person imparting, the question that becomes the owner? It possibly could be. Our case law is yet developing it, and our laws are not yet able to deal with them. There's a lot of case law in this area, even just for non-Indigenous content. And if we put ICIP on top of that, it's another challenge. So I'm showing here the free prior informed consent being free in that it's not coerced consent. Prior, that it's the use, we're telling First Nations people before we use it. Informed, that we're giving them enough information about the nature, context, and use of the Indigenous cultural material. And consent, that's where we're looking about how we get consent. And that can be a challenge with these days with, do we use agreements? How do we get consent from a community? How do we get consent from groups that might share content? So all of this requires deeper thought. Now, I just wanted to take an example of AI and how it can make fakes. And the platforms create and hallucinate. And here's an example of a false Aboriginal art style. We used a case study here of Wiradjuri culture to demonstrate this. And please note that this is purely a demonstration and it's not intended to cause offence, but I'm showing these images that were created on Stable Diffusion. And the prompt given to the AI was Aboriginal art, Wiradjuri art, and Wiradjuri country. And this is the art that it came up with. And a reverse Google image search shows how the AI is drawing from examples from the internet. And you can see there it's bringing up things like even a car and to make the artwork. And is that Wiradjuri art? It's not created by a First Nations person. How is it getting and sourcing that information and giving it up to me as the person asking for it? So it draws attention, this example, to the ways by which AI could create inauthentic works and infringe on individual artists' own copyright and Indigenous cultural and intellectual property rights by using artworks that it can glean from the internet without consent or without proper attribution. So, it's quite stark and a concern for artists. And on top of that, we have the call of First Nations people to have Indigenous data sovereignty, a term I'm sure you've all heard a lot about in recent years, and growing internationally. And what that is the right of Indigenous people to control data collected about them, their culture and their country, and to know where it goes, how it is managed and accessed by others. So as we see that call gaining greater awareness within government and universities, it is for us to think about how we respect this Indigenous data sovereignty. So within all of this, there are also opportunities for empowerment. I'm not saying that AI is all a bad thing. It's definitely some great uses that can be made of it if First Nations people are empowered in the process. And there are many examples of First Nations people using AI in positive ways. Language revitalisation, for instance, there's been great uptake in that. AI can help create resources, translation tools. It can have virtual language tutors. It can give you access to the archives. Young people like using technology, enhances their ability to be engaged. And, we see Indigenous communities developing AI systems to preserve and teach their languages. And if these tools can work with protocols, they're controlled by First Nations people, bring in data sovereignty, it could be okay. Mapping country is another example. Imagine AI being able to analyse country from satellite, from drone technology, to support land management or environmental and ecological restoration. And we're seeing that happen up in Kakadu, where they're monitoring by drone and AI paragraphs, bringing back magpie geese populations. So this cutting technology can combine with traditional knowledge to bring out good results. Sharing stories. We have virtual reality, AI-driven storytelling platforms that can help bring in Indigenous stories to new audiences. And that is really useful to preserve the stories for future generations, passing on that cultural practice. We have caring for country as well. I already mentioned the example with the magpie geese, but there is a lot of rangers, Indigenous rangers, working alongside scientists to deal with water quality, mine remediation, and just also dealing with invasive species, what have you. So these are all good ways. And also health innovation. Our community-controlled health sector is looking for AI solutions in the way that they care for their patients. And I think personalised medicines will be the way to go in the future. So AI is being used by Australian Indigenous communities to detect things like heart disease. And the technology allows people to access culturally safe healthcare in that way. And these are all good things. So the possibilities are very exciting, but they must always centre on Indigenous agency and consent. So when we look to solutions, there's going to be a sort of a strategy that we need to put together. And I don't think these challenges are insurmountable. I think if we harness AI in ways that respect and benefit Indigenous peoples, the way that we do that is embed Indigenous protocols and Indigenous cultural and intellectual property principles at every stage of AI development and deployment. So it will be things like ensuring data sovereignty. First and foremost, Indigenous communities must retain sovereignty over their data, and that means encouraging mechanisms to ensure that the use of the knowledge in the systems is guided by custodians of that knowledge. And the Mayam-Nari Wingara Indigenous data sovereignty principles are useful in that they explain Indigenous people in Australia have the right to control data, have a say of how it's created, managed, shared and used. And it also includes how it's stored and analysed. And the principles also state that data should be meaningful and useful for Indigenous communities, helping them to make decisions and govern themselves. And it must be available to them in ways that make sense for them. And most importantly, data has to respect their rights and interests, handled with care, accountability. And so the Mayam-Nari Wingara protocols deal with that. Cultural context in AI design is also important. AI systems must be designed to recognise and respect the cultural context of the data they interact with. And for example, if an AI program is analysing in Indigenous art, it should look at protocols and recognise to the best that it can. And that is a challenge for systems. We need to also include Indigenous designers. A pathway must be created for First Nations tech people to ensure that our voices are in the system. And it's good to see the out of the black box Indigenous protocols for AI written by Angie Abdillah, Megan Kelleher, Rick Shaw and Tyson Younger-Porter, who are explaining how Indigenous knowledge can be used to guide design and practices of AI systems. AI projects should also be Indigenous-led. To shift the power dynamics, we need more Indigenous voices in technology. So how do we get people involved with steering committees. What are the new positions that may come out of this collaborations that involve custodians being able to manage their natural resources, revitalise language, and share knowledge in ways that align to their values. I think best practice protocols are the way to go, and I'm talking about the protocols that I've been working on for the last 25 years, True Tracks, as a model that could be considered. And True Tracks is 10 principles that require people to think about how they engage with First Nations people when they're using their knowledge, and go through these 10 principles, not just in a way that is the minimum sort of copyright standard, saying like, oh, it's in the public domain, I can use it now. It is around thinking through these principles. So the first one is respect. And this is about recognising that First Nations people have the right to their knowledge, and acknowledging that the protocols are there. Self-determination is acknowledging that they should be empowered in decision-making. Consent and consultation, ensuring you are contacting the owners before using it. Interpretation, Indigenous people being recognised as the primary guardians and interpreters, and ensuring people are there to advise on results. Cultural integrity, the next principle. A big issue, which is looking at the context so that it should not be harmful or inappropriate. We next have secrecy and privacy, which respects laws around sacred and ritual knowledge, and men's and women's business, customary law, and also personal privacy of individuals. So it's a challenge here to think about how AI could do this, but nevertheless, it is something we should do. The next one is attribution, making sure that you're attributing the owners and custodians of ICIP. So a huge machine AI generated platform would take that away. It may not acknowledge the individual knowledge holder, the artist, or the group where the knowledge comes from. The right of people to be acknowledged, I think, is very important, because there are a lot of data sets already in collections that we don't know where it comes from. And metadata and how we keep those records will be important. Benefit sharing is there. Indigenous people have the right to share in the benefits from the use of their culture, and this is really key when there's going to be commercial use and application of ICIP, but I think it applies to other situations too, because we need to make sure that if we're sharing the knowledge, let's imagine if we're using it to develop some sort of innovation in bush foods. Now that's an industry which is really developing in Australia, but only about 2% of the industry is led by Indigenous people. So how do we make sure that they are involved in what gets put into these AI systems? Because how fast an AI could work out what is nutritious or the adaptable or applied to a particular situation can be ramped up with there, but we need First Nations people there alongside it if it is their knowledge. Maintaining Indigenous culture is the next principle in the protocol, and this is where we think about the impact to cultural use. How is a way that we as outsiders might interact with knowledge impact the right of the community to talk to it, and also how are we keeping connections with the community beyond? And this might require thinking about consent being ongoing and not just a tick the box at the start of a process. You're going to go back and get consent if there are other uses. It also requires you to think long term for the next generation and keep good records about who you're going back to talk to, because that is not often kept. And so the descendants are the ones that should be having this cultural practice of speaking for it. And it also includes empowering First Nations people to have their own collections, keeping places, databases as well, so that they can be involved in AI projects or making decisions about how they want to commercialise or work with partners to unlock possible opportunities. The last one is recognition and protection. And this is the one about recognising the rights in contracts, in law, having protocols, because protocols are, in essence, a framework that is about getting people who want to do the right thing to follow it. Bad things can happen, bad people don't need to follow it. And also, if we put protocols in contracts, we can make them binding against the parties to contracts. But there's a legal principle called privacy of contract, which means the other person who might access the resulting content born out of a contractual relationship is not bound by the contract. So protocols, we need to tell other people that they need to follow protocols, so that industries need to have this as an established practice within their ways of doing things. Now, apart from the True Tracks protocols, we also have the AI-specific protocols and guardrails that are being developed by the government at the moment. And there's a large discussion paper out at the moment which is covering that content to develop 10 principles, which are voluntary guardrails for AI developers, AI users, to apply throughout the AI supply chain. And they set out some explanations from what both the developer can do, I guess the developer of the platforms, and also the user who's doing the prompts and asking the AI to create things. So these 10 principles, and I don't have them to share with you today, but they're not specifically ICIP related, but in the discussion paper, it does call for support for Indigenous data sovereignty principles when developing AI programs. And I think a feature of these principles needs to think about how, when using the data, that we do no harm to culture, to people, to the world. And in that way, we're bringing in the principle, the Indigenous principle of caring for country and care, in the way that a machine would learn, and the way that we will use machines to create content. So I've gone through 3 solutions, with including Indigenous designers adopting strong protocols and ensuring this in data sovereignty. But as we navigate this intersection, we're not just talking about technology, are we? We're talking about values and ethics, and we're talking about respect, reciprocity, and justice. And I don't think AI is inherently good or bad. I don't think it is. It's the people that are creating them and using them that have that. And so the question is, how will we use it? Will we allow it to deepen the wounds of colonisation, or will we harness it to empower Indigenous peoples and cultures? And this is where the role of leadership and collaboration is important. The way forward is a process of leadership and collaboration across all sectors. Governments must implement laws and policies that protect ICIP in the digital age. And we're seeing a new law being looked at now. There's calls, after many years of calls for a law, the government is currently looking at developing a law for the protection of fake arts and also the recognition of Indigenous knowledge. So governments must continue to do that. Tech companies and those working and designing on AI must consider these protocols and how they work with Indigenous people when they're using Indigenous cultural and intellectual property. And educational institutions will have to think about protocols, but they also must train the new generation of First Nations technologists and advocates. And I think they're going to be quite unique. Imagine what they could be. And as individuals, we all can play a role and demand transparency from the platforms that we use and support Indigenous-led initiatives and advocate for ethical use of AI in the spheres that we influence. And on that note, I want to return to the legacy of Barak and Wonga, who fought tirelessly for survival and dignity of Wurundjeri people, but also for Aboriginal people, for First Nations people. And in their time, the challenges were different. Can you imagine them facing and seeing what AI might do? But I think the challenges in part remain the same. It is to protect what is sacred, the land, the stories, the people, the culture. And we as First Nations people are caring for our future generations. We're thinking not just this generation, not the next or the third, but the fourth, fifth and sixth generation. And I think that's a principle that we can all take on board as we move into this challenging space. And we can ensure that the world reflects the digital world reflects these principles. And we can build systems that honour Indigenous knowledge and protect the rights of custodians and make amazing things. And AI should not be used to erase culture. It should be used to elevate culture. And so back to the phrase, AI got no dreaming, I think it captures the essence what's missing. Dreaming is about connection between people, place and knowledge. And AI can never replicate this, but it can be guided by it if Indigenous people lead its development and we all respect Indigenous cultural and intellectual property rights and work and collaborate to build a world that brings First Nations and Indigenous people together to create amazing things, to entertain, sustain, heal, and overall make the world a better place. Thank you.
Okay, thank you very much, Terri. That was fantastic. I've got to admit that it's only in the last couple of months that I've been starting to use AI to lighten the workload a little. But I must confess that your talk today has really opened my eyes to ICIP, which my colleagues in the MTC are starting to move on. So thank you very much. That's fantastic. And we've got 10 minutes of question time now. So if people would like to ask some questions of Terri, it'd be great. Yes, you have a water here.
I think it'd be first, Terri, that was fantastic. I've never been there, but the oyster bar below the Grand Central Station at New York features this incredible vaulted ceiling, and it was patented by a Spanish constructor in the late 18th century. And it was an intangible system that had been used for centuries in southeastern Spain, and they themselves had acquired it from North Africa. So there was this kind of, this is over 100 years ago, this kind of offensive appropriation of something that had been intangible, made tangible through law, through patent. So I was just wondering with the AI, which seems to rely on granularity and being able to connect lots of discrete bits and bobs and build a kind of fake story from it, whether the law might focus more on the intangibility of culture rather than the artifacts. So instead of being the petroglyph, it's the collection of them, so that it's the spiritual identity of that particular phenomenon rather than each particular piece that would be grabbed by an AI engine to be the representation of something cultural.
Yeah. Thank you. Well, there's many layers to your question, but I think the intangible cultural heritage is, and the recognition of it, is gaining traction in international intellectual property forums. For example, the World Intellectual Property Organization, which is the UN organization that harmonizes and brings to the world all of our IP laws, including copyright and patents law, has this year concluded a text for the recognition of traditional knowledge when a patent is filed of a genetic resource. So it will require patent applicants of genetic resource patents to disclose country of origin and whether or not the source was traditional knowledge. And that's pretty amazing because never before has IP international regimes recognised Indigenous knowledge, but also it is challenging to patent applicants and inventors, big companies that are, looking at outcomes, basically, to think about how do they get consent from a group. And we also need, on top of that, the Nagoya Protocol, another international convention. It comes off the Convention on Biological Diversity, which is looking about benefit sharing for First Nations people and local communities, saying that there needs to be access and benefit sharing agreements with people that come on country and take the resources away. We only have that implemented in Australia, in Queensland and the Northern Territory. I think Queensland's got the best model, but we're yet to ratify it and for it to be implemented across Australia. But it is changing the way people would see access to knowledge as being, we can get access to that resource because it might be in a collection and collected and taken from Indigenous land for another project, but you might have to disclose it now in this process. And the trigger is hopefully not that you just disclose it, but if there's a Nagoya Protocol, that you're working with First Nations people to collaborate on that. And that, to me, introduces the process and the act of First Nations people speaking for the resource, but also collaborating with researchers, universities, scientists, big companies, to work on, medicinal products, nutraceuticals, or, fashion items or whatever. I think that becomes more process focused. And we're also limited by an IP system. If you look at patents, they only last for 20 years, after you file them. There's also a space when you file a patent, it does require registration, unlike copyright. But as you file it, you have to note the claim of the invention and write it out in a public database, which anyone can see. And so that might not be the best thing for First Nations people if that knowledge is not already widely publicly known. If it's a secret sacred or the most important medicine, strong medicine, it might not be suitable for it to be the subject of a patent that's going on a world patent database. So we're seeing questions like that come into a system, which was really about economic benefits, as incentives for people to create things that would benefit, humans, being challenged by, I think, much more principles which are more about, as you said, the intangible stuff, for people to know that knowledge and care for it and live with it. And it can be very challenging. So next off the rank for the World Intellectual Property Organisation is two other pieces of laws at an international level, which is draft articles on rights for traditional knowledge and rights for traditional cultural expression. So they will be continuing to think about that. We do have examples of those laws in other countries of the world, so it can be done. And if we look at the great biodiversity and the amazing knowledge that we have in Australia, I do think it's worthwhile doing, and it's from a place of recognising First Nations rights to knowledge in Article 31, from from that connection, that cultural connection continuing, but it is also about economic opportunity. And I don't think that should be understated or taken away from Indigenous people. They have the rights to build their economic prosperity off the back of their knowledge, and the laws and the protocols can give a pathway for that.
Thank you so much, Terri, for your time. It's been really interesting to hear, especially about how there can be a difference between having a right and then a mechanism to actually recognise and be able to enforce that right. So breaking that apart in the way that you have has been really enlightening. I had a specific question about your experience with advocacy, including on the copyrighted AI, the CAIRG. And I'm wondering how companies like, or entities like technology companies have taken on the true trust principles and what the reception has been like, especially given a lot of the taking in these large language models has already happened.
Yeah, no, thank you for that question. I think it's yet to be seen how they will embrace it as an industry. And we've just seen that guardrails discussion paper come out a few months ago. But I have seen examples of projects that large tech companies have worked with First Nations people on, and they have embraced the protocols. So in the absence of law, they're trying to, within the project, think about how it's governed by recognition of Indigenous cultural and intellectual property. And they're working with traditional custodians and designers. And I also should state that the CSIRO recently adopted those principles in its work and put together quite a large set of protocols and guidance for their teams. And it is also requiring them to look at how they contract and have agreements with First Nations people to recognise this. So it is really changing the landscape here when we're thinking about Indigenous-led projects that follow protocols. People have to consider how they work together and deal with things like free, prior, informed consent, attribution, cultural integrity. But it also has to follow through with the agreements and how the project is managed, as I said, with what you might give to the First Nations person after and aligning your goals together. Or an example might be recognising them as the same equivalent knowledge holder, like scientist, Western scientist, Indigenous, First Nations scientist might be on equal footing. So all of these things will challenge how I guess systems have already been done. But I am like sort of, I have a positive outlook on it when I see someone like CSIRO having it, but it's yet to see how the big tech companies will take that on board and embrace protocols as an industry.
Thank you very much. That was so stimulating. I almost don't know which question to ask. But I'm going to ask, to what extent does the effective protection of Indigenous cultural and intellectual property depend on an effective regulatory framework for AI more generally? And are there any areas where protection of ICIP actually requires a different approach to the sort of general position? And how do you design your regulatory framework to address that?
Yeah. Good question. And I think the answer will be in the development of the Indigenous cultural and intellectual property law. What will that be like when it's being formed. And the government has been looking at this recently. There's been a lot of inquiries, like the productivity inquiry around the fake arts, which got a lot of attention. Just today, Senator Stewart released her support in her report on the inquiry into the First Nations business sector, that there should be laws for ICIP so Indigenous people can have the economic opportunities. So the second limb of the law will be looking at this wider knowledge piece, which could cover things like the knowledge of plants, animals, could cover things like cultural practices like fire management, could cover a whole lot. Stories of country, the people, the story of place might be there. So I would say that it would be looking at something like a process of where people get consent. And then the law would have to work out what that process is. There an adequate process of consultation and consent? Because it would be, who do you get consent with? How do you have fair agreements with First Nations people? And there would be penalties for use of when you're not getting consent. There would possibly need to be things like exceptions for cultural use. And in some of the laws internationally, they have carved off things that are already widely publicly known. For example, like maybe a boomerang is already out there and it's impossible to, enter into an agreement with First Nations people for that. So these are the things that the laws are looking at. And I think that it's got to strike the mark because we want it to be, it's got to strike a balance between having it there for protection of First Nations people, and those who want to use it need to be able to, within the law, get consent to some level of, I'm not saying certainty, because I don't even think copyright law gives you certainty, but to some extent you've got to be able to know that the process you followed has some sort of rigour to it. And I hope that the law can bring rights and also bring that. And the AI guardrails law, I think, is going to be much more principles based, and we will need the ICIP law to address situations that are all happening even without AI, but are just exacerbated by AI. And a big part of all of this, I think, is going to be in the tagging, the metadata, and the way. I think AI could probably even solve that question. So over to the experts on that. Yeah.
Okay, we've got one more question.
Long time listener. First one. Lawyers said master schools can never dismantle master's house. The AI robot has already bolted. For Indigenous folk in the university, what can we do to make tools dismantle the master's house?
Yeah, well, part of it's bolted. I think we're still we're still there. We still have the opportunity. A lot of content might be there, but there are ways that we can, as users of the content, think about how we can apply protocols to the use of it. And this is why those 10 principles can be used by anyone to think about how they are going to use the content that they benefit from the AI, look at it through that lens. And like, you might get the AI to create something, but before you apply it, you can think about how these protocols go. And it will require, I think there's much more to be developed with these tools, and developers will need to think about them in their developing. So what we need to do is to think about how our creative ways of thinking and, using information might also bring alongside it protocols. And the guardrails about AI are doing that. Like, it's like, don't harm humans, don't pollute the world, don't discriminate. So the ICIP laws, the ICIP protocols can be alongside that as well, to think like, how can we hold up culture in a way that we're elevating it and not exploiting it as we have done in the past? And I may be an optimist, but I don't think it's too late.
Okay, can we thank Dr. Terri Janke one more time? Thank you. That closes our Barak-Wonga oration for 2024, and thank you all for coming. It's been a very enlightening night. Thank you very much, Terri.
Thank you, John.